Good afternoon. I'm Jim Townsend, and I'm director of the Carl Levin Center for Oversight and Democracy here at Wayne State University Law School. It is my pleasure to welcome you to today's presentation by the winner of the 4th Annual Award for Excellence in Oversight Research, Professor Jonathan Shaub of the University of Kentucky's Rosenberg School of Law. Before introducing the moderator of today's presentation by our winner, I want to say a word about the Award for Excellence in Oversight Research. The Levin Center established this award in 2020 to recognize important contributions to the emerging field of oversight research. At the Levin Center, we believe that the first job of a lawmaker in Congress or a state capitol is to be the eyes and voice of their constituents. In other words, to conduct oversight, to get to the heart of important questions and share those findings in good faith with the American people. As our founder and namesake, the late Senator Carl Levin said, and I quote, "You can't have good oversight you can't have good government without good oversight." And these days, more and more, we are convinced that the same holds true for democracy itself. So to understand this critically important process, to help us measure the quality of legislative oversight and understand its impact on how it can be improved, we need to attract scholars to this field and recognize those who are really making important contributions to the field. So that's what the Levin Center Award for Excellence in Oversight Research is all about. Each year, a selection committee comprised of faculty members from Wayne State University Law School, from our political science department, Levin Center staff, and occasionally scholars from other institutions review submissions of not yet published scholarly work that addresses significant legislative oversight issues. They can be at the national, state, local, or even international level. We accept submissions on a rolling basis until June of each year, so keep that on your calendars. And for any additional information you'd like about the award, please visit our website. That's levin-center.org. And then we'll also post the URL in the chat so you can jump right to that. At that site, you can also read the work of prior award winners and actually watch video of their presentations. So hopefully that's valuable information, and we're very pleased to share it with you. I'd now like to introduce Professor Jennifer Bird-Pollen, who will moderate the presentation and Q&A with this year's award winner. Jennifer Bird-Pollen joined Wayne State University Law School faculty just this year in 2024 after 14 years at the University of Kentucky's Rosenberg College of Law, where she was a colleague with our award winner. Professor Bird-Pollen is a professor of law and the Alan S. Schenck Chair in Taxation here at Wayne State. Jennifer is a nationally recognized expert in federal tax law, especially regarding matters of distributive justice, wealth transfer taxation, and international tax. And before joining the academy, she worked in the field in the tax department at the law firm of Ropes and Gray in Boston. So we are so pleased at the Levin Center to have Professor Bird-Pollen join us today. And with that, let me congratulate Professor Shaub. Again, thank Professor Bird-Pollen and turn things over to you, Jennifer. Please take it away.
Well, thank you so much, Jim, for that kind introduction and for inviting me to participate today. The first thing I wanted to make very clear is that I had nothing to do with the selection of my friend Jonathan Shaub as the winner of this year's award. The first I heard that of who this year's winner was when the public announcement went out, which is when I wrote to Jim and told him what a great selection I thought it was, and that started the ball rolling towards my participation today. So with that, let me say it is my very great honor and privilege to introduce the winner of the 2024 Levin Center Award for Excellence in Oversight Research, my dear friend and former colleague, Jonathan Shaub. Professor Shaub is the Norman and Carole Harned Professor of Law and Public Policy at the University of Kentucky J. David Rosenberg College of Law, where he has taught since 2020, when some very clever chair of the hiring committee helped bring him to the campus. Before joining the UK faculty, Jonathan served as an attorney advisor in the Office of Legal Counsel at the Department of Justice, and also as Assistant Solicitor General for the state of Tennessee. He currently serves as a special advisor, again in the Office of Legal Counsel with the White House. After law school, he clerked for Judge Niemeyer on the Fourth Circuit and also served as a Bristow Fellow in the U.S. Solicitor General's office. He earned his law degree from Northwestern and his BA in philosophy at Vanderbilt, where he also played safety for the football team, which is having a very good season, if I'm not mistaken. I think this is likely a relatively unusual background for a distinguished professor of law. And I'll just say, in addition to his many scholarly distinctions, publications in top journals, recognition, including today's award for his excellent work. He's a deeply kind, funny, thoughtful person, and beloved by the students who are lucky enough to learn about constitutional law from him. So I'm thrilled that our students here at Wayne are getting an opportunity to hear from Jonathan directly today, and all those here on the webinar. So as you know, he's joining us today to talk about his forthcoming, now award-winning piece, Common Law Executive Privileges. So Jonathan, I will turn it over to you.
Thank you, Jennifer. You're gonna make me cry before I even start the presentation. So I want to say first, thank you to the Levin Center. I was telling Jem when I was in DC, I went to one of the kickoff events for the organization, and I had already been thinking there is so little scholarship out there about oversight and privilege, and I think it's just a wonderful thing that the Levin Center has done to encourage it, to connect scholars, and it's been a great resource for me, and I am truly honored to win this award. The papers that have won in the past are wonderful. Many of them are cited quite a bit in this paper. So I'm really honored, and thank you to the Levin Center and to Jennifer for being here and agreeing to moderate this. So I'm going to talk 15 to 20 minutes about the paper, and then I'm happy to answer questions. And if Jennifer has some, I'm going to share my screen here. So this should work. And this paper has been something I've been working on for a long time, and it kind of grew out of a past paper that I wrote on privilege. And I wanted to sort of do a few things in the paper. The first thing is to sort of collect and trace, although at a pretty high level, these kind of common law privileges that have been asserted by the government, what I talk about in the paper as common law executive privileges. There's been some scholarship on these individually, some more than others, very little scholarship that sort of connects them and brings them together. The second thing I wanted to do, and this is probably what led really was the impetus for the paper, was at some point in my research, I went back and I was reading the briefs in the Nixon case and sort of tracing the United States v. Nixon and how we got to the opinion that we got. And I was really surprised. And so what I want to do in this paper is sort of put Nixon back in context about what the parties were actually arguing at the time. Because I think what it stands for today was never really contemplated by the parties or probably the court, and is largely dicta in the opinion itself that has sort of been taken on a life of its own, in part because the executive branch has used it to its advantage. The third goal is to discuss some of the pathologies of oversight and privilege that arise out of this dicta from Nixon. Some of it has been embedded in these executive branch doctrines that have been able to thwart congressional oversight, but I also want to make sure to show that some of those doctrines are in response to some of the positions that Congress has taken. And then the last thing I want to do is propose some paths to reform that I think are more consistent with historical practice and that would relieve some of the constitutional conflict that is at the heart of oversight today. And that would also align our discussion of privilege in the oversight context with a more general discussion about secrecy in government, transparency in government, and the policy rationales that underlie that, which has largely been divorced from the conversation about oversight. So to go to the beginning, the paper starts by looking at sort of three state policy, what one of the old treatise writers calls state policy privileges at common law. And to be clear, they're not necessarily delineated as separate by all the treatise writers. They all cite sort of similar cases. Some of the courts sort of lump them together. But I tried to lay out that there's a thread, at least, for sort of three principal types of privileges. One is the kind of well-known state secrets. Well, one of the treatise writers talks about this as the rationale to protect security. And there's threads of this. There's an old Supreme Court case called Totten, but then it really crystallizes in the United States Supreme Court recognition of the state secrets privilege in Reynolds, which was a common law decision, although they talk about it as a constitutional overtone. So more on that later. The second type is deliberative process privilege, which is a bit more controversial in terms of whether secrecy is needed, I think. Some of the treatise writers talk about this as free communication for the public good. The idea that the government needs to be able to talk to itself in confidence so that people are free to say what they want, free to have candor. Eisenhower, when he coined the idea of executive privilege and really the term executive privilege in response to some of the McCarthy era communist hunts, this was his rationale, and more on that later as well. This comes into the U.S. in case law, really in a form of Justice Reed's opinion in Kaiser Aluminum, which is a court of claims decision. But Justice Reed had sort of missed his chance on the Supreme Court. His papers show he wanted to go much broader and talk about the need for this kind of secrecy for candor. He wasn't able to in the Toohey case. And so he did it in a court of claims case where he's sitting by designation. And that became largely the basis for the common law privilege in the United States. Nixon cites it repeatedly. And then the third thread is this law enforcement. And the treatise writers, if you look, they really talk about this as the informer's privilege. There's no sort of general law enforcement privilege. It develops over time, in part because of the efforts of this man, Hoover, to protect law enforcement files and techniques. Eventually in the 70s, the DC Circuit recognizes this in Black. And there's threads of this idea that people who provide information to the government should be protected. And then it really doesn't get broader than that until, the 20th century. So this is sort of the backdrop of Nixon. And if you look at what happens in the case, it largely proceeds along these kind of common law grounds. So before the case that became United States v. Nixon, there's the original subpoena, grand jury subpoena, that's filed by Special Prosecutor Archibald Cox. And it gets resolved ultimately in the DC Circuit, which says you have to turn these over, looking at this as a common law matter. And then, of course, we have the Saturday Night Massacre, and it kind of goes away. We come back with Jaworski. We have a trial subpoena for the same Watergate tapes, or there's similar Watergate tapes. And now we've got another case. And so Nixon files a motion to quash a subpoena for the Watergate tapes in the district court in the context of a criminal prosecution of a different defendant. And he asserts executive privilege. But what he means by executive privilege is an absolute, unqualified president's privilege of immunity from judicial process under all circumstance. His arguments in the case are entirely about the separation of powers and the idea that the president is not subject to judicial process in terms of whether or not to disclose information. In other words, the president has a privilege to decide whether or not to disclose confidential information, and no court can sort of question or overturn that discretion. Nothing about the sort of type of information aside from the idea that these are the president's conversations and so they're confidential, but it's really about an immunity from judicial process. Jaworski, in his brief in Nixon, he concedes that there's a presumptive privilege for intragovernmental documents. This is the deliberative process. It was recognized previously in Sirica that there is long-standing judicial recognition of executive privilege. It's common law, military and diplomatic plans, and intragovernmental documents reflecting deliberations. So there's no dispute in Nixon that there is a common law protection for some of this information that can be overcome by the adequate showing of need. That's what happened. That's how the court resolved Sirica. And Nixon doesn't really contest that either. What he says is, that doesn't matter because as a constitutional matter, I am exempt from judicial process. And you can see a little bit of this in the arguments, right? So Potter Stewart says to Jaworski, are you arguing there's no such thing as executive privilege? And note, they're using the term executive privilege a little bit differently. Nixon talks about executive privilege as an immunity for the president. When Stewart is using it and Jaworski here, they're talking about it as the common law executive privilege, the idea that deliberations are protected. Jaworski says, no, sir. And Stewart says, is this a common law privilege? Is that what you're saying? And Jaworski says, yes, that's what we've decided. Courts have decided this in a number of cases. And so this is a little bit later, and there's some more dialogue on this, but Thurgood Marshall says, and he's talking about Reynolds, the state secrets case, didn't we say it has some constitutional overtones? And Jaworski says, yeah, we've sort of hinted that, but we have never placed it, the privilege, in the Constitution as far as I'm aware of. And the president's counsel can't come up with anything either. And so Nixon's argument is on this immunity, right? So this is Brennan saying the president's position, if it's correct, is that he's the sole judge. He wants us to agree with that as a matter of constitutional law. And Marshall, again, you're saying the absolute privilege to decide what shall be released and what shall not be released is vested in one person and no one can question it. And the president's lawyer says, insofar as it relates to the presidential conversation, that is correct, sir. So United States v. Nixon is a case about the president saying, I cannot be told by the court what to release and what not to release. And the special prosecutor saying, yes, the president is subject to the court process, and there are these common law privileges, executive privileges that may protect this information, but that's going to be analyzed and the court can decide whether it's overcome or not. And Nixon never really disagreed with the second part of it. And what the court does when it writes the opinion is take Nixon's brief, which is layered with constitutional arguments about the separation of powers in support of his immunity argument, and it intersperses that into discussions about the kind of information at issue. And I think in part of it is because it happened so quickly, right? So it's Judge Sirica orders May 20th. You have to give him the tapes. May 24th, Nixon appeals. Jaworski immediately goes to the Supreme Court and says, I want you to take this case now, cert before judgment. The court reaches down a week later, grants cert, gives the parties 3 weeks to file briefs, about a week after that to file replies, an argument a week later, and then it writes the opinion and issues it 16 days after the argument. So this all happens very rapidly. There's an impeachment that is gaining steam. It's incredible pressure on the court. And the court goes out of its way to sort of give some credence, give some weight to Nixon's constitutional arguments. And so it talks a lot about the constitutional basis for its holding. And some of the key language, it says, the privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. For this sentence, it cites a district court decision that relies almost totally on Kaiser aluminum, and it also cites the Sirica case, and these are common law cases. So it doesn't cite anything that sort of locates this in the Constitution. Instead, it puts them in, it just sort of cites as this is the need to protect this information, and then it layers it with constitutional language. It never talks about the common law background, despite there's a case, EPA v. Meek, that was shortly before Nixon, that was all about the deliberative process. The court was fully aware of it. But it really talks about this as a constitutional privilege, talks about deriving from Article 2. And this becomes embedded in follow-up cases. So in Nixon v. Administrator of General Services, it talks about the scope of the privilege recognized in Nixon. So sort of categorizing this as a new privilege as opposed to just an application of the common law deliberative process. In the In re Sealed case, EPSI, which is one of the sort of major cases in this line, the DC Circuit distinguishes between presidential communications from Nixon, which is rooted in the constitutional separation of powers, and other types of executive privilege like deliberative process, separating the sort of constitutional privilege. And so the place we land after Nixon is the immunity arguments have become in some ways conflated with this idea of a constitutional protection for particular types of information. And I kind of, you'll have to excuse my attempt if it doesn't work, but I kind of have a diagram to sort of try to show how this works. So the Nixon arguments were an absolute presidential privilege over the disclosure of information. And the paper traces some of this, and I've done it in a previous paper too. But there's a long history of executive branch writings that show that the president has some privilege or immunity against Congress trying to enforce its information demands, right? So this goes back to the Washington cabinet saying that he should only has to turn over what he thinks is in the public interest. There are resolutions of inquiry where the House will demand information from a cabinet official, but then only request it from the president. So this is all collected in a memo to Truman. It is published by a DOJ employee named Herman Wilkinson. This is repackaged by Attorney General Brownell in 1954. It is part of Nixon's argument. It is a idea of the president being exempt from a particular kind of process. And so Nixon's argument is he is exempt from judicial process. But Nixon rejects that. But it also has the common law privileges and all this protection, and Nixon inextricably roots these in the separation of powers. And so what Nixon creates as a result is this amalgamation, or I call it a conflation, of an immunity from process, which is a constitutional doctrine, with a privilege or non-disclosure that is based on a type of information, like deliberations or state secrets. And how this comes out through the Reagan administration and into today is an executive branch doctrine, largely created by OLC, that says executive privilege is a singular privilege that has various components, including deliberative process, presidential communications, state secrets, law enforcement information, and added in the Bush years, attorney-client information and attorney work product information. And these components track common law privileges, but they are presumptively constitutionally privileged under Nixon. And they trace this all the way back to Washington by combining this absolute presidential power over disclosure with the common law executive privileges, and Nixon allows them to do it because Nixon puts these sort of common law privileges into sort of constitutional language. And I think this conflation has led to a number of pathologies that really make oversight a game where no one is speaking the same language. And, the paper goes into more detail, and I don't want to take up too much time, but we talk about a former president asserting executive privilege, which I think is largely an oxymoron in that privilege historically has been a determination by the president that the release of information would harm the public interest. How can a person who is no longer in office have authority to decide what's in the public interest? Third-party subpoenas. So this is Congress, right, can subpoena a third party that may have contracted with the executive branch, can try to get information from the third party that relates to the executive branch. It creates a difficult situation on both sides. There's an old case, US v. AT&T, where the Department of Justice actually sued AT&T to stop them from handing over information to Congress because of this sort of third-party problem. And that's because the executive branch doesn't have control, but both of these result from the fact that the information is not privileged until the president asserts a constitutional privilege over it. It's only presumptively privileged. And there are none of these sort of common law protections that provide a sort of milder form of protection, but that also don't require the same sort of processes of going through the president every time or through the White House. This has led to what I've called a lot of prophylactic executive privilege. The executive branch has doctrines, some of which are in litigation now, whereas an executive branch employee can't go show up for a deposition without agency counsel. This is justified in part by the idea that the president must have authority to decide whether something is released or not, must be able to sort of supervise executive branch employees providing information to Congress. And to not allow agency counsel to be there would burden that authority. But that's, again, sort of grounded in this idea that there is a constitutional basis for controlling these wide swaths of information that are really, in fact, sort of traditional common law privileges. And then the other pathology, which I think is very important, is this. And you look at the common law treatises, you're struck by it's really a policy discussion, right? What's the policy in protecting an informer's need? How does that relate to the need for the information here, the informer's identity? Let's analyze the policy. And the way that executive privilege is currently sort of used in oversight, these policy rationales are almost entirely gone because the executive branch side is the same. It's executive privilege. And the congressional side is, what's Congress's need for this? Can they overcome the privilege? It's qualified after Nixon. But we never get into the specific policy. Should Congress have law enforcement information in a particular instance? Let's analyze the policy rationales underlying giving law enforcement information to Congress versus the sort of constitutional discussion of the president has asserted privilege. Can Congress or a certain House sort of overcome it? So I have this part from the paper that I think is a somewhat good summary. I don't think there is any such thing as what I call a constitutional evidentiary privilege, meaning a constitutional privilege that is based on the type of information. Just because it's a certain type of information, it is automatically constitutionally protected. The president has the authority to protect it. Nixon really invented this category of privilege largely by using dicta from Nixon's separation of powers arguments. I don't think we should have no protections for confidential executive branch information. I think the common law privileges do a pretty good job of protecting some of this. I think we also have a lot of case law in the context of FOIA and civil litigation that would allow courts to get involved if necessary. And that would allow, for instance, information from past presidencies could be analyzed under a common law privilege framework without the need to go through the constitutional question of, can a former president assert privilege? How should we think about that in the context of the current president's assertions or decisions? If information is in third-party hands, the government could come in and again raise these sort of common law privilege interests in the information if it needed to, without having to go through this, again, a constitutional question. And so I think the Nixon conflation, as utilized in the current executive branch view, has really severed the idea that common law privileges were designed to protect from the entire sort of debate. And it's become a question of whether something fits within a category of information. If so, it is presumptively privileged. And then we go through the question of whether the president, whether the White House, the agency head is going to authorize the release of that. What's the accommodation process? I think all of that could play out as a matter of common law and get rid of the sort of constitutional overtones. The one problem, the big problem with that is Congress doesn't like common law privileges. Congress has long had the position that common law privileges cannot shield documents that are subject to a constitutionally rooted subpoena. I find this somewhat questionable, given that this nature of the argument, right? There are other constitutionally rooted subpoenas, like judicial subpoenas, to which common law privileges do apply, attorney-client or spousal privilege or priest-penitent, so forth. So Congress would have to allow for the use and assertion of these sort of common law privileges. And I actually think it would benefit them because it would remove the constitutional basis. It would allow some room for legislation. I don't know if it's likely to happen or not, but to me, that would be a much better way forward. So that's all I have. I will say one thing, that these are solely my personal views. They don't reflect any other views of any other government entity that I have worked for or work for. So just to be clear on that. Let me stop the screen share.
Well, thank you so much for that, Jonathan. So I think, as Margot has been noting in the chat, we are hoping for lots of questions from you in the audience. Those of you watching in the classroom here in the Wayne Law School building, I think that one volunteer has agreed to type questions into the Q&A box. And we have one already. I want to note that As Jim mentioned at the beginning, I am a tax scholar, not a constitutional law or executive privilege scholar. So I hope there'll be lots of questions. I see in our participants list many excellent scholars of con law and some of the questions that Jonathan's raising today. So I would love it if many of you shared your questions. I know Jonathan would as well. I do have some questions, and I wanted to follow up a little bit first on what you said, what you were talking about towards the end, Jonathan, and ask you to say a little more about if readers, if you've fully persuaded readers of the paper that the privileges should be thought of as common law and not executive, do you see sort of immediate next steps? Would you ask for legislation if you could wave a wand and have Congress act? Would you ask for federal legislation on this? Do you think there are other things that whether it's judges or legislators ought to be thinking, or I suppose executives considering trying to appeal to the privilege should be thinking about at this point?
Yeah, no, so it's a really good question. I think, and I've argued before, like Congress and the executive branch are so diametrically opposed in their constitutional view of privilege. I mean, Congress's view is Nixon establishes the presidential communications privilege as the only constitutional privilege, and it is the only executive privilege that can be asserted against Congress. They lost that argument in the Fast and Furious litigation, where the court held that deliberative process is also a constitutionally based privilege that can be asserted against Congress. That case settled before we got an appellate decision. That's a similar argument is currently happening between the parties in ongoing litigation. So I have argued in the past that at some point we don't need a judicial resolution of the dispute, like whether the information gets over, but we might need judicial resolution of some of the fundamental constitutional questions at stake, right? I mean, if a court comes in and says, this is a common law privilege, that I don't think that means the Department of Justice is going to go turn over all its FBI files whenever they get a subpoena from whoever the chairman of the House Oversight or the House Judiciary Committee is. But it might reset the way that they approach the oversight and the way they think about it. So I think you could have some court decisions that alter the sort of fundamental precepts that both parties are operating under that could really advance it. I do think you could try to have legislation if you could find something that both the executive branch and Congress would agree on. I think that has proven very unlikely in the past. And when Congress has tried to move forward with legislation that then maybe a later administration doesn't like, then they have said this is unconstitutional or we're not going to comply with this particular piece of it, or could issue a signing statement. So I think in the current framework, it's very hard to legislate because everything's constitutional. And so you can't overcome the president's constitutional prerogative with legislation in the executive branch's view. And you might need some sort of fundamental shift in the constitutional framework, which I think would probably happen eventually in court decision.
So we've got a couple of great questions here, some of which are going to give you a chance to elaborate on some of what you've just said. So the first question is from Michael Stern, and he asks, is it possible to separate the content of executive privilege from the question of who decides whether particular information is released? And put another way, if there is no remedy to challenge the president's assertion of executive privilege, does it matter whether the assertion is based on common law or constitutional privilege?
No, I mean, I think it wouldn't matter. And that was Nixon's argument, right? I mean, Nixon was essentially saying the courts have no power. And so at that point, it doesn't really matter what the privilege is. It's about who's got the power of enforcement. I do think, and I think Nixon is important in its actual holding, in that it rejects that. And so these cases can go to court, and questions of common law privilege or the president's authority can be litigated. And so I'm not in any way suggesting that Nixon was wrong in that holding that these cases couldn't go to court. My argument is that it was wrong in characterizing the underlying protection of the information as a privilege based on, or at least as it's been interpreted, as a privilege based on as a constitutional privilege based on the type of information, as opposed to just saying, yes, you can come to court, and the DC Circuit had already done this, and yes, this is protected by common law deliberative process privilege, and it's overcome here. The same thing would have resulted, and we would be in a much different place, I think, in terms of the world of oversight. So, I mean, the questions about how much Congress can do to enforce its demands against the president, I think, are much harder because they haven't been addressed. And there's a lot of history that suggests Congress's oversight authority has some limitations derived from separation of powers. But I don't think that's at stake once you get into court.
I'm going to ask a follow-up question about that from, I think, a former Levin Center winner, Emily Berman, who asks a version of the same question, but I think focuses it a little differently. So will calling something common law versus constitutional change things in practice? So in other words, can Congress overcome that Nixon privilege, thinking more explicitly about those policy interests that you talk about? Would the executive be any less resistant? So again, a version of that point, but asking maybe more about whether what you've described here would allow for more of those policy interests to be brought in.
Yeah, I mean, the thing is, I don't think it would change a ton in the sort of normal course of oversight because largely what the executive branch says now is you're asking for sensitive law enforcement information and we're not going to give it to you unless you can show us you really need it, or we're going to have some accommodation, like you can only view it in camera or whatever. And so I think the same points would be made, and that's part of my point in the paper is to show that the confidentiality interests that are being asserted are the same under the current framework as we think about under common law. I think the difference is where it goes from there. And and the other big difference, which I think Emily noted in her question too, is this idea of the prophylactic privilege, right? So that the current view is that the president has the ultimate authority about the dissemination of this information. And so things like deposition counsel are grounded in that authority as a burden to that authority. Whereas you could say if there was a common law privilege, I'm in this deposition, this is protected by common law privilege, and Congress would have to figure out a way to resolve that. Maybe it would go to court. But the executive branch actually has no way to do that right now unless there's an assertion of privilege. So I actually think it would facilitate the resolution. And then to the last point, it would facilitate the resolution by analysis of those policy questions. You have law enforcement, you have deliberative process, you have presidential communications. On the executive branch side, they're all analyzed the same. There's no inquiry currently into whether they have a greater need for secrecy. It fits within the category and the president has asserted privilege. And then can Congress overcome it? And so you get a little bit of the policy consideration of whether Congress needs it, but you don't get the other side of the balance of how much confidentiality is needed in this particular instance.
So we have another question on here that's following up on something you've referenced a couple times now, which is this idea of prophylactic executive privilege, and that it would clearly extend to staff. But Jennifer Carter asks, would that just mean the direct staff in the executive office, or could this, or maybe it's a question about sort of what happens now and also what would happen were we to move in a different direction. Does this extend to executive branch agencies and executive branch agency staff as well?
Well, so to be clear, when you're talking about the question of this staff question, and what I've also talked about as prophylactic is there's a doctrine of immunity that is related to privilege, which OLC has said senior presidential advisors are immune from compelled testimony. And that has been limited to the White House, senior most White House officials advising the president. But that has also been largely based on there's a sort of autonomy and independence idea that the Congress shouldn't be able to just summon the close presidential aides. But there's also the privilege idea that these people are the ones in contact with the president. And if Congress can summon them, there's danger of sort of undermining that confidentiality. So I think from the way I'm proposing, the difference would be you look at congressional oversight authority. And so the executive branch can say they lack authority to compel a presidential advisor to testify. That's a constitutional question, right? And that's a question related to, can they compel the president to testify? That's a question about Congress's authority. And that to me is a separate question than can they compel information about a conversation, right? That happened, whatever form it takes. And that's a separate question. To me, that second question is one of privilege, common law privilege. And the first question is one of congressional authority, and Nixon really put the two together. So I think to answer the question, as I think I understand it, it's not really about sort of where it extends. It's more about having a sharper delineation between questions of congressional oversight authority, how far it extends into the executive branch, which has basically never been addressed by the courts, and how we should think about certain categories of information that are, everyone sort of agrees, or most people agree, they're somewhat confidential, some are very confidential, that we can't just sort of put on the internet, how we should consider and think about that information when Congress wants it. And that question about this sort of categories of information is where I think common law privileges could do a really, maybe a better job than what our current framework, which is largely grounded on Nixon.
So I want to turn the discussion a little bit. One of the questions we thought about asking you in advance was partly for the benefit of the students watching today, was to ask you to talk a little bit about the Office of Legal Counsel, the office itself and what they do. But I want to tie that to a question that Kel McClanahan submitted, and I'm just going to read it because it's a great question. So every time Congress attempts to legislate in an area where the executive branch claims dominion, like classified information or even the state secrets privilege, the Attorney General fires off a fiery letter extolling the virtues of Nixon and regretfully telling Congress it sadly cannot tell the president what to do because Nixon said so. So as a practical matter, how can we change the way executive privilege is viewed when every DOJ under every administration will very much die on this hill? So maybe you could think about that question also in the context of telling us a little bit more about some of the way that this works in practice.
Yeah, no, I appreciate the question, Cal. And it's well, apparently my lights are going out. I don't know, these timed lights. It really kind of goes back to the first question, that I am, I'm a realist. I don't think there's going to be an executive branch administration that's going to come in. It's very unlikely then say, okay, fine, we're going to give up all of our prerogatives, and we'll just let Congress ask for whatever they want. We've seen, we did a symposium here at Kentucky, and I actually got a chance to interview my former boss at OLC, Paul Coburn, who I think's on the call too today. He just recently retired, but he tells the story of the transition from the Bush administration to the Obama administration, and there was at the time a pending lawsuit where the House was trying to force former White House counsel Harriet Miers to testify about the firing of U.S. attorneys. President Obama on the campaign trail had made statements suggesting he thought she should testify. And so the case is being litigated and the transition happens. And the question is, does the executive branch continue to make the arguments? Or do they change positions, particularly given what the candidate Obama had said on the trail? And he talks about a meeting with career people and institutional people who talked about it and went through it in the Department of Justice. And then the president ultimately supported the position, although the case was settled. And then if you look a few years later, President Obama claimed immunity for one of his senior advisors, David Seamus. And so it's the tools that are existing are there. And particularly people often I teach a presidential power seminar. By the end of the seminar, everyone, although they all have bad things to say about OLC, although I try to defend us, sometimes, but they're like, how can OLC say this? They're just building on their own work. But I think you also have to look at the other side, in that the subpoenas are much more common. Oversight has become much more aggressive. The polarization has made it in some ways more partisan, where many oversight requests, often the high-profile ones, seem to be made for political purposes, not for, legislation of some kind. And so I think that's part of the problem too, is when an administration faces aggressive oversight that it views as sort of pretextual or partisan or not really in good faith, it's more willing to rely on sort of past doctrines that it may have questioned in order to combat it as opposed to sort of give in. So it's really been, I think if you look at the history, it's like kind of just ratcheted up. Like each side does something new to try to overcome the other side. And it gets more and more and more sort of entrenched on two different sides. Um, and this goes to give us all the way back to Kel's question and the answer. It kind of goes back to my first answer is I'm skeptical that there would be a significant change in the executive branch's view of this until there's an adverse court decision, a precedential one by probably the DC Circuit. I mean, I think the Office of Legal Counsel's internal guidelines are largely that, that it tries to stick by past positions. It's kind of a stare decisis idea that's supposed to provide sort of institutional as opposed to partisan advice, right? But if there's an intervening decision, particularly a precedential one, they will reconsider opinions. I think the executive branch abides by the Supreme Court's statements. And so I don't think it's going to be sort of willingly handing over authority, but I do think it's very possible, particularly given how often this is now going into litigation, that the court will say something adverse in some ways and force a sort of rethinking. Sorry, it's a very long answer, Cal.
That's great. I'm gonna push back and ask again for you to talk a little bit more about OLC and its role with respect to the executive branch and the Attorney General's office. But another question sort of along these lines is, as you're talking about that and thinking about how the executive branch relies on decisions or opinions issued by OLC, Congress doesn't really have its own OLC. Should Congress form an Office of Legal Counsel to issue opinions which it then can rely upon in court? So maybe you could talk a little bit about what the OLC does and how this might work if such an office were formed at the congressional level.
Yeah, it's an idea that's been proposed in various places, and I know the GAO did a study on it. And I think it's a good idea. I actually think Congress is doing more of it lately because they're litigating this so much more, which forces them to sort of, I mean, if you want to find the current congressional position on privilege, go read the briefs that are filed in the litigation or the filed in Fast and Furious, and they're consistent. I mean, there are things like congressional research reports that do this as well. I think OLC's role in the executive branch is largely to provide, sort of independent legal advice on questions that are uncertain. And a lot of what OLC advises on are things that courts haven't. So you think about, war powers and national security, statutory questions, like really boring ones, like appropriations clause questions or Anti-Deficiency Act questions, questions about creating monuments. I mean, I have colleagues who spent years of their life working on these things, things that weren't really in the news until in the last decade, like the emoluments clause or, whatever, but they're rarely litigated. No one's bringing Anti-Deficiency Act claims because there's not really an avenue to get into court, but it's a statute that says you can't use, money that's not been appropriated, and there's criminal penalties, and agencies are really concerned about complying with it. So OLC's sort of independent advice giving role, particularly with respect to the White House, I think is really important because it provides I think an independent institutional view. The criticism that people have of OLC is that it always favors the executive branch. But of course, it's the president asking, is something constitutional or not? And to say something is unconstitutional, you got to find something, right? And there's no court cases, rarely. There's very little constitutional text. So OLC does say that, and they do often say no or push back on things that the White House wants to do. But they try to sort of do I think the best answer to a question in light of what's out there. And I think Congress has less need to act in ways that require sort of an independent legal opinion readily. They're not immediately like sending troops somewhere or something like that. But I do think their institutional position is often harmed by their party switching places, right? So like the McGahn litigation I talk about, this is a case where the House sued to force Don McGahn to testify. during the Trump administration, and it went up to the D.C. Circuit, and it's a very important decision on standing in the D.C. Circuit, and it went to cause of action. The panel dismissed it. It went back to the en banc court. They were ready to issue an opinion that almost certainly would have overturned the panel opinion and said the House has a cause of action. And then the case settled after the election and the change in administration. And if Congress were acting as an institutional matter, I think it would have wanted to continue that because it was almost certainly going to get a very favorable opinion that gave it a cause of action to proceed. And it almost certainly would have won the merits about the immunity argument. I mean, even the judge who dissented said, from the en banc said, who would have sided with, the executive branch on the justiciability issues said these immunity arguments are, these are highly questionable. So I think maybe having something like OLC, I mean, the House Counsel's Office does this a little bit, but if it were more robust, but there's also a lot of moving pieces that make it difficult in terms of the House structure and the way it turns over every 2 years. And there are pros and cons, but I do think it lacks a little bit of that institutional interest that the executive branch is very good at protecting.
Okay, I'm going to take a minute to remind folks watching to submit questions through the Q&A box if you have them. We have about 10 more minutes for our conversation. I have a few questions here. I'm going to combine two of the questions in our Q&A box right now. One from Elise Bean, is it OLC policy to ignore district court decisions it doesn't like? Maybe you can opine on that. But then Cal follows up to say, if OLC prefers a version of stare decisis and will often only change its position after a contrary court decision, how does one get it to change its opinion on a question that isn't or can't be litigated?
Two good questions. So I think I wouldn't say it's OLC policy. I think the view is if there is an intervening court decision that is, even if it's maybe slightly different, or the OLC will incorporate that into its analysis. And so I don't think district court decisions are not precedential, right? They're not binding on anybody. And so they are a decision in a particular case. So the immunity issue isn't a good one in the sense that the DOJ has litigated and lost that issue twice in the district court, two district court opinions that were very dismissive of the executive branch position. In the opinions that came out afterward, OLC analyzed the decision in the Myers case which was written by John Bates, and said, we understand what he said, we disagree, and here's why, and it maintained its absolute immunity position. OLC doesn't have a policy of ignoring them. I think their policy is to consider them, but I don't think the executive branch feels bound to follow a district court decision. A DC Circuit opinion, I think, would be different, and then obviously a Supreme Court decision even more so. So I think that's part of the problem, is that we don't have these precedential decisions. In terms of if there is no court decision, I think that's right. That war powers is a great example. People might disagree with OLC's view of the president's sort of inherent authority to use force. There's a long history of opinions that are from different presidents that take a pretty consistent view that the president has significant authority to use sort of unilateral force. And I don't know there's not a way to get that sort of those opinions reconsidered by intervening court decision, right? So it's not going to be litigated. I think there would be more of like a political pressure, right? It would take an administration that came in, but then you would often have the possibility that the next administration then would just go right back. So I think part of the reason OLC tries to adhere to the stare decisis policy is that so it's not that easy for the next administration to come in and say, well, I don't like this and this and this opinion, so forget them. Because then it would just, every administration, like the opinion becomes worth even less. I mean, it's worth very little right now. The Supreme Court can ignore it, or courts can ignore it, and they often do. But I think it's even harder, it becomes even less worthwhile if there is no sort of institutional view that other administrations will also follow this and be bound by what OLC has said.
We've got two questions, which I'm going to try to combine a little bit here. So Dave Rapello asks a version of something you've talked a little bit about already, which is specifically thinking from the perspective of Congress. If we were, talking to Congress about how this approach could be practically used to their advantage, what makes this sort of common law approach better than the constitutional approach from the perspective of Congress? But then maybe you can tie this to an anonymous question we received, specifically about law enforcement information, current litigation about this, and the House is litigating it, and whether judicial recognition of law enforcement privilege is something, that is at all affected by the analysis that you have here as well.
Yeah, so from Congress's perspective, I think they would benefit because they would be able to say, here's the information that we want, and you can tell us what the common law privilege is that protects it. But there's doctrine on these common law privileges, and there's policy rationales. And so they could have that fight, however it occurs, with DOJ, whoever it is. And then to me, like, that's where these things can also be litigated, right? So it's as now we almost sort of never get to what the actual disagreement over the information is, right? So maybe Congress says we should get everything except for informers' names, but the only privilege is the informer's privilege. And DOJ says no, like there's a much broader law enforcement privilege now. So that's something that can be, that's a relatively straightforward legal question about the scope of the privilege in the oversight context. It's not so easy when they say we want this information and the DOJ says, well, this is all protected by these confidentiality interests, which is the language that we often use. And so let's talk about accommodations. And there's really no joining of issue, I guess, on legal issues. It's only about a force of will. And then only when they schedule a contempt vote will there be an assertion of privilege. And so they're each trying to, or they'll subpoena somebody and say, come for a deposition to talk about this response. But all these are like what I think of as constitutional self-help measures, right? They're ways to sort of force the other side's hand that have nothing to do with the actual legal dispute at issue. And so what I want to happen is, I think there are real questions about how much law enforcement information Congress should have. And to answer the question, there are very few judicial cases on this. Circuits have varying descriptions of law enforcement privilege. My paper goes through some of the scholars who've done a lot of writing about it and thinking about, like, should we protect law enforcement techniques? But these are all things that courts are well equipped to decide in sort of the common law method, but they never come up in the oversight context. They never, the question of, should these files go to Congress because of the impact on law enforcement is a decision that never gets really discussed. It's only something asserted by the executive branch and then said, well, you don't have a need for this because we've shown them to you in camera or done something else. So I view the benefit as, like, we can all be on the same sort of legal framework and have these arguments, have court cases that are about issues that we understand what the issue is, as opposed to sort of abstract constitutional concepts and sort of uses of self-help.
So we're just about out of time, but I'd love to give it back to you for just a minute to say what you think we ought to all be looking out for. I mean, obviously we have sort of pending litigation in various places and potentially, issues arising in the coming weeks and months, that we might see some of these privileges claimed. Do you have thoughts about what those of us less versed in the topic ought to be thinking about as some of this stuff hits the news?
No, I mean, I think it will be interesting to see how these litigations proceed, particularly with the election and what happens with the election and how much institutional interests there are and how much of the sort of political interests overtake them ultimately. And if you see after the election, I think a divided House and presidency, whichever way it falls, then you should be prepared for a lot of privilege discussion and immunity, because that's what the House, particularly if, divided Congress, you're not going to pass much legislation. In recent years, the House's primary thing has been oversight. So I would, and when you see these, what I would, I guess one thing, I'll leave it with this, but when you see these oversight disputes, like there's a history to them that I think people often don't know or neglect, and they see this one thing and think, oh, this is crazy or this is a new position. But I would caution people to think and to look at what their side has done before critiquing the other side, because in the oversight world, there are many, many hypocrites about whether privilege should exist, depending on who's in the presidency and who's not. So.
Well, it is my great honor to again congratulate you, Jonathan, on this fantastic paper and on the award. On behalf of Wayne State Law School and the Levin Center for Oversight and Democracy, thank you for your time today and for sharing your paper with us. Thank you to everybody who participated in the webinar. If we were all in person, we would now give you a round of applause, Jonathan. But thank you, everyone, for your participation today. We appreciate it.
Thanks for having me. Thanks, everybody, for attending. And, I'm happy to field comments or questions on the paper. It's not published yet, so the editors will let me stick a few more things in, I think.
Excellent. Thank you all.